We want to welcome everybody to our gathering this afternoon. The topic is very serious but probably misunderstood, so I think this one will be very helpful to most employers. We're going to be talking about probably the two issues that really have a tendency to bite a client, and when it happens, they're unhappy, they're mad, they get sued, and they didn't know anything about it. So this is a very important session, and I want to just take a minute. I talked to Kyle before we started, just to give you a sense of the urgency. The industry, the insurance industry, as you know, has one function, and that is to provide coverage for loss. That means if your car gets hurt, you got insurance, they take care of the car. If your house gets in trouble, they take care of the house. That's the whole premise of insurance, providing you with a recovery from loss. What's happened about 15 years ago that many people really don't realize is that the insurance industry decided that there was a need for employer practices liability insurance, a brand new science, a brand new product, something that had never really existed in the insurance portfolio. And I want to stress the fact that that product was built by the big names in the insurance industry because they saw a real need. And as we go through this, you'll see that you can get bit by one of these issues we're going to talk about, and it's going to cost you 20 grand, and you're going to tell me, Larry, I didn't really know, I didn't do anything wrong, blah, 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 but it still cost me an attorney, and in the end I didn't do anything wrong, wasn't convicted, but still cost me 20 grand. So the principle of employers' practices liability insurance is to replace that loss on the part of your costs if something has to be litigated and handled, and we'll talk more about it later.
Thanks, Larry. I want to thank everybody for joining us. I'm Sean Owens. I'm one of the senior payroll processors here at Partners, and today I want to talk to you guys just a little bit about an important topic, sort of a good segue that Larry had, also something that can get you in hot water and you don't even think about it most times, and that's the importance of good timekeeping with regards to keeping track of your employees' time during a given payroll cycle. The Fair Labor Standards Act, FLSA, requires employers to accurately record hours worked by non-exempt employees, and it requires that to pay them for all the time worked, including overtime in a given payroll cycle. Now, it seems simple enough, and most of us have a pretty good grasp, but there's a few things that we feel like we can point out to help you with not only timekeeping, but also keeping record of that time. So let's get started. What can you do to make the practice of timekeeping easier? Well, the first thing that we're going to touch on is to have a good understanding of your payroll cycle. Are your employees paid weekly, bi-weekly, semi-monthly, or monthly? Each pay cycle is different, and obviously weekly is each week, bi-weekly would be every 2 weeks. Semi-monthly at Partners we would consider to be twice a month, and of course monthly would be once a month. What day do you pay your employees? This ties directly in, and it's important because if you don't give yourself enough time to collect hours before you're processing your payroll, you're going to have some unhappy employees who may not be getting paid for all of the time that they worked. So just a good rule of thumb right off the bat, we like to tell a lot of our clients to try to give 48 hours before a scheduled pay date. So have your payroll cycle in 48 hours ahead of time. That allows you to get all of your time in, to correct any errors, answer any questions, fix any missed punches on a time clock that may have happened. The second thing I'd like to talk about is making sure that you have a simple and effective system for tracking time. Accurate timekeeping should not be taken lightly. Wage and hour lawsuits, especially those claiming that employees were not compensated properly for all their hours, are the most common types of lawsuits brought against employers. There have been a lot of advances in software and data collection tools, and these tools can help track time, but a good system will always improve payroll processing. Whether that be manual or automated, digital, whatever it may be, having a system we feel like is the most important thing. Don't just fly by the seat of your pants and hope that, you know, John is turning in the right hours. The next bullet point, employees must understand the time system and be able to use it. This ties directly into the previous point. Make sure, take the time to explain your system to your employees. Help them understand, even taking the time to explain to them what each different type of payroll cycle is. Address the questions that they may have. It's very important that your employees understand the system. And it's good practice for employers to come back and test your system with your employees, with the employees that are clocking in, with the supervisors who are managing that system. The time tracking system, again, for the administrative people who are responsible for paying and running payroll, should be simple enough that processing your payroll is very easy. Make sure your system can handle all your needs. Some questions that you can ask: does it track time properly for your type of work? Will it keep track of special pays, lunch breaks, vacation, holiday? These are all questions you need to ask yourself when you're dealing with a system for keeping track of time. Make sure that it's simple, efficient, accurate, and fast. Whether you're using a handwritten system or a complex digital automated system, make sure it's easy to read, it's easy to calculate. This will help you cut down on errors and keep your employees happy because they're going to get paid properly. And you're not going to be making payroll mistakes, which could cause a lot of issues with your employees. You know, everybody's got their scheduled deductions coming out each month: car payment, house payment, bills. So we got to make sure we're paying our employees properly, and a good system is going to help you do that. Again, just touching back on what I commented earlier, and this goes in with time tracking system, making sure it's simple. I can't stress enough, you know, whether it's quarterly or twice a year, however you want to do it, make sure you're reviewing your system for the accuracy and compliance, and stay up to date on the rules that are necessary to reflect any changes in wage and hour laws. Make sure you're reviewing your systems. There's always things we can look at to do better with the way we keep track of time. Finally, I want to touch on record keeping. On our last session, Kyle spent some time talking about this, and I want to expound on it a little bit more with regards to time tracking. There's a lot of bad stuff that can happen to you as an employer if you aren't keeping track of time records. You got to keep your records. So it's the duty that in the eyes of the court, the duty to maintain accurate records is always going to fall on the employer, not the employee. Keep track of your payrolls each and every time you process any type of payroll. Let me say that again. Keep track each and every time you process any type of payroll, regardless of whether it's a regular payroll cycle, a commission, a bonus, or any special additional payrolls. Have a good backup of hours worked or units paid that you can access easily. And then finally, keep your records under lock and key, safe, or on a secure server that's password protected. Limit your access. You don't want to have a lot of people having access to this, 1 or 2 of your people. should be having access to this. And make sure, it's easy to get to it in case you need it for any backup purposes that may come up. If you have any questions about timekeeping, record keeping, different systems that are available out there, obviously this is something that Partners is very knowledgeable about. We deal with a lot of different systems, so if you have any questions about any of these items that I've covered, please don't hesitate to give us a call. Thank you, guys. Next, we're going to bring in Ron Wofford. He is our Director of Safety and Risk Management, and he's going to touch on the safety tips for September.
Good afternoon, everybody. Today we're going to talk about ergonomics, the possibility of employees from long periods of having a bad desk or a bad workstation can manifest themselves, and it's typically after several years of working in that same setup. First thing we're going to talk about is good ergonomic practices so you can reduce those injuries. There may be tasks in the workplace that put unhealthy stress on your body. If those are in your case, make a note of those and provide it to your supervisor. If you're the employer, take notice, walk through your workplace and look at how people sit, how people answer the phone. Do they hold the phone with their shoulder? Do they have a headset? Do they sit looking sideways at their monitor? Is their chair too low? Is it too tall? Are their arms at an angle or level with their desk work surface where they have to type? Look for those things and anything that might be a problem. The goal of ergonomics is to identify these dangerous tasks and prevent injuries by changing the way you do your job. Examples of these activities that may cause injuries are heavy lifting, such as warehouse-type work, or even in an office environment where you have cases of bulk paper. Tight or strong gripping, more or less in a warehouse-type environment or manufacturing. Repeated motions where you're doing the same thing over and over. Awkward positioning, like we talked about. A piece of equipment that has vibration in it, and there are gloves that you can buy that help reduce that. We'll talk about in a moment. And then contact stress, if it's something that makes an impact and you have to hold onto that machine while it makes that impact. Examples of actions that you can take to prevent these injuries. Always examine alternatives to lifting. Use pallet jacks, use forklifts. Get a second person to help you lift that item if it's too heavy. Increase your grip strength by keeping your wrists straight. Also, if you do something repetitively, you build up a tolerance to it if you do it the correct way. Maybe even exercising when you're not at work with a hand squeeze tool or a stress tool. Spread the repetitive task out through the day, or you may even possibly spread it out between employees where one employee is not having to do that task all day long. You can have 2 or 3 employees split that up throughout the period of the day, and one employee doesn't take all of the risk for the injury. Stand on a platform to bring your work closer to you. Use anti-vibration gloves or wraps, tool wraps on the handles. Report symptoms if you think that you have an injury that's caused by repetitiveness or something. Report that injury or the suspect of an injury or problem to your supervisor immediately. That's all I have for today. If we have any questions out there or concerns, or anybody that has had something like that in their workplace, feel free to chime in or type it in box?
Ron, I see a lot of this being out there calling on clients, but it's very difficult when a company's growing. A lot of times they're using old stuff, you know, and they're picking up a desk here, and they're picking up this and that, and your kids are, I call them kids, but your employees are using a phone book to raise up the computer screen, or the guys are trying to put a keyboard underneath the desk and it really isn't the right fit and it doesn't really work very well. Those are things that can really bite you if something goes wrong down the road, because when they come in and look at it, they go, well, this is not proper.
Exactly right, Larry. And let alone the used furniture market out there, those chairs and desks have usually been abandoned or given away or worthless, put to a resale shop because they weren't functional in their workplace. So be careful what you buy. Another thing we deal with in today's time is everybody wants vintage, old desks, old workstation, maybe making a desk out of an old door. You still need to take in consideration the work height. The standard desktop height is 30 inches. Your typical chair height for the seat is 16 inches. Now that's not going to fit everybody's body because we have different fluctuations in height between men and women, and even just women in general. You have tall women, short women. So you have to make that workstation fit or adapt to the person that's going to be using it. Good point there.
All right, thank you guys. Next, I want to, before we get too far into this, just make sure as Kyle gets going here, please mute your phones, and if you do have a question, type it in the chat box, or if you'd like to, you can chime in with your question, but please, we would encourage you to use the chat box on the screen. For the main part of the presentation, harassment in the workplace, I'm going to go ahead and turn it over to Kyle.
Thank you. I appreciate folks taking some time this afternoon. This is somewhat of a difficult subject for many of us. It's something that, as Larry mentioned before, is sometimes lurks beneath the surface that we're not even aware of, and it tends to blindside us when a situation occurs or some type of charge or lawsuit is filed. A lot of times it's something we're not even aware of. And so we're going to talk about today not just how to prevent some workplace harassment, but also begin to recognize it and how we can understand and have the obligation to understand what's going on in the workplace. A lot of harassment that we'll talk about today stems from some discrimination laws that are applied to this. So when you look at the areas that we're going to be learning today on the slide, we're going to define that harassment, the importance of preventing it. We've already touched on that a bit. Understanding the difference between illegal harassment and conduct or unprofessional behavior, and understand the laws that to protect individuals against harassment, as well as what is our responsibility as leaders and managers of organizations in handling these complaints as they may pop up. A bit of understanding around what the courts and the regulations call harassment. Again, as I mentioned, sometimes it comes in forms of discrimination. There's several acts out there that we won't go into detail on, but protect individuals from discriminatory practices, as well as what we know as unwelcome verbal or physical contact. Again, this can be based on a person's race, age, color, religion, sex or gender, national origin, as well as their age and disability. That could fall underneath a discriminatory act. So the other thing I want to highlight on this slide is the last bullet point of adverse employment actions and retaliations, as we know it in the workplaces around retaliation. One of the most costly events that can occur is if a individual does come forward with a concern, does come forward with a complaint, and we somehow push that aside in a sense, and they sense that they're being retaliated against. I like the analogy that we see in a lot of political circles of the cover-up. It's not necessarily the act that causes the downfall of some of our politicians. It is when they get busy about the actions of a cover-up associated with that act. And so that's very similar to retaliation. We're not necessarily at some point dealing with the act of the complaint, but with the actions that we've taken, which is separate, against the employee for coming forward. Maybe we change their hours, maybe we change their desk, maybe we move them to a different department, even a different location. All that can be viewed as retaliation. And normally most courts will apply triple damages to retaliation if that's found to be a part of the case. So something to be highlighted and have an understanding around. So we talked a little bit about what harassment is. Let's talk about maybe what it looks like. A lot of us can relate to behaviors better than words. So starting at the bottom, it can come in a lot of different forms. One is written form. Today we do a lot of texting, we do a lot of emails, and that harassment can come in that written form. And let me stress to you, just because you hit delete on your keyboard, that email never goes away, nor does that text ever go away. Those items are discoverable in any type of lawsuit, and if you do get served with a lawsuit, one of the first things you'll see is to preserve all communications. And all communications being written communications, verbal communications, emails, texts as we know them. So something to be cautious about is what you actually put in writing. We also know that harassing behavior can involve physical contact. We know what that looks like sometimes. It's unwelcome touching or hugging or kissing or even standing too close to someone. We all have been in situations where our personal space has been invaded. And when someone gets too close to us, we have a tendency to take about a half a step back. So be sensitive to that and be respectful of one's personal space. Some cultures, some company cultures and relationships and environments are more touchy than others. I know organizations, and maybe one of yours, where it's more common to hug someone than to shake someone's hand. And so what we're really talking about is that unwelcome touching, that unwelcome hug. I'm not telling you never to hug anybody in a professional environment, because many times that's perfectly acceptable. But we're talking about more unwelcome type of physical contact. Visually, those cartoons that we pass around at times, whether we do that electronically or photos that can be seen, can be offensive, can also cause harassing claims in workplaces. Nonverbal, those are those gestures, whether it's throwing kisses, whether it's just prolonged staring, can again contribute to that harassing behavior that individuals don't appreciate. And then of course the verbal comments, whether it's some racial comment, a derogatory comment about an individual, something sexual remark or sexual offensive jokes or stories. All these can contribute to that harassing behavior. And again, different individuals have different levels of tolerance. And so that's something we're not necessarily clear on, but we do need to be sensitive to in the workplace. You know, when in doubt, the best rule is probably don't do it or don't say it. Let's talk a little bit about harassment versus inappropriate behavior or inappropriate conduct. Many times in the workplace, someone acts unprofessionally in a manner that's inappropriate, not necessarily illegal, but something that you probably wouldn't support in your workplace as being acceptable conduct. So harassment refers to illegal forms of discrimination. So when we use that term harassment, we're talking about illegal activities. As we know, employees and managers say things at times, act in certain ways that's not necessarily illegal, but inappropriate conduct, inappropriate behavior that we put in society now a term around that called bullying. We talk about bullying, whether that's humiliation or intimidation. It can exist in any levels and across our organizations, from supervisors, some subordinates, co-workers, just general colleagues can mistreat or maybe even repeatedly mistreat one in a number of different ways, which is, again, we would call inappropriate behavior. It's not necessarily illegal. It's not necessarily discrimination or covered under any of the laws or regulations that we're going to discuss, but it is inappropriate, and we need to understand the difference between that. I want to look at a little bit more about what this inappropriate behavior may look like, meaning that bullying, that's bantering, teasing at times, comes across as a bit of verbal abuse, whether it's in the form of some type of criticism, even use of profanity, humiliating someone in front of a group. Probably the most common area that we see is in gossiping. Gossiping many times is the biggest distraction that we have in our workplace. If one is involved in gossiping, whether they're just listening to that or actually actively participating in that, I can assure you that they are not focused on the performance level that they need to be focused on to be successful in that workplace. At times we see bullying where one would steal credit for work performed by someone else. Overt threats, sometimes colleagues, sometimes even managers will remind people of how they worked hard for them to get them this raise, to get them this promotion, and hold that over their heads in a bullying type of way. So at times that's related to unrealistic workloads. I've seen circumstances where a manager would put a lot on his team and then remind them that raises are coming up, performance reviews are coming up, and that hangs over their head as somewhat of a threat. So these are items, and there's many more examples that we could go through, but I want you to have a good understanding of what that workplace bullying can look like and what it can include. I want you to think about this situation, and I'll discuss it briefly. But let's say that you have a manager that's constantly and publicly criticizing his employees and calls them stupid and lazy. Would this fall under the illegal harassment category? Or would you think this was more workplace bullying? I'll give you just a second to consider that question in that activity of that manager. Even though this is a public display of criticism and is repeated and obviously not considered a best practice to refer to employees as stupid or lazy, it's not necessarily illegal. This would be more in the workplace bullying category. I'm not saying it's a good practice. I'm not saying that you don't need to coach and counsel that manager, that activity, but it probably would not be something that would be viewed as a discriminatory practice. Let's look at another example. Let's say that same supervisor refers to one of his employees as an old gal who is over the hill and has problems using the computer because of her age. Would this be illegal harassment or workplace bullying?
Better call an attorney.
Yes, Larry is correct. This would be something that would be under harassment due to one's age. Those references of that old gal, the references of someone over the hill, and even having issues performing because of their age would be considered harassment and discriminatory practice. And I think that's fairly obvious to all of us as to why that would be that way. I do want to talk a little bit more about some prevention on harassment. We kind of understand what it is now and kind of where it comes in. Again, it can be based on a lot of different factors, and we call these factors protected classes. Protected classes would be race or color, sex, national origin, religion, disability, age, even veteran status would be a protected class. In our society today, our leaders, governmental leaders, have determined that most individuals in our country are in one protected class or another. In fact, it's easier to say who's not in a protected class than who is in a protected class. Individuals that are not in protected classes are white males under 40 who are not veterans or disabled. Those are the only individuals in our society today that are not in a protected class. So with that being said, our exposure and our liability is with a vast majority of the population of our employees. So it's something to be aware of. There's been a lot of attention recently, in recent years, about sexual harassment. We'll talk about that in just a moment. But it is, the courts have ruled that as managers, as employers, as owners of organizations, it's our responsibility to be very diligent, excuse me, I can't say that word right now. Why don't we say that we need to be about preventing such harassment? This needs to be part of our organization, because it used to be that we had a defense as owners of organizations that when these things snuck up on us and we got sued with something and we had a charge filed on us, and we could say, well, we didn't know anything about it. Nobody told us. They should have told us. We could have done something about it. But now the courts have ruled that we ought to know what's going on in our workplace. They've taken the position as owners, as leaders, as managers, we need to know what's going on in the environment of our office, in the environment of our businesses, in the space that our employees work, because it's our responsibility to provide a safe work environment, which includes safe from discriminatory practice and safe from harassing activities. So it's our responsibility to be proactive with that.
You know, Kyle, last month we were talking about hiring practices, and one of the things that is often missed, particularly in certain size organizations where they haven't really become maybe full-blown professional management people. You hire a nice guy and bring him in, he's going to work out in the shop. Well, you got a real possibility, if you just dump him off and say, here, go back there and see Bill, he'll take care of you. You better hope that Bill's smart enough to take some time to introduce him to the guys and to give him some respect and to let him know that we're all here. Help me if you got a problem, if you don't know what to do. But so many times the boss just says, well, you go out and see Bill, and then he doesn't know how well this employee is being brought into the company, and is the guy that he sent out to see is any good. You know, many times these supervisors get moved into spots that they didn't really grow up doing well themselves, and boy, some of those can turn into some real sad cases. So you lose a good employee because he really didn't get brought into the clan very well, and it's a very significant part of losing people.
I think that's a good point. Your point's well taken regarding some type of orientation process, onboarding process, whatever applies to your business, but something that, as Larry points out, should be considered. There's not necessarily the right answer for everybody, because all of our environments are different, all of our workplaces are different, but it's something you should consider in bringing on that new hire. Look a little bit more. I don't want to spend a lot of time. The point is, I want you to see that there are plenty of laws and acts, regulations out there. The big one is Title VII, which is the Civil Rights Act of 1964, that we've got to comply with on all levels. There's equal pay. We've already talked about age discrimination, as well as Disability and Rehab Act. The final one there is around that whistleblower activity, in that those reports from those employees are protected in that we cannot discriminate or retaliate against them in any way. So that's, again, something that some employers struggle with, as they may view that individual as someone that may be somewhat of a troublemaker, or someone that we may want to push out of our organization because they filed some type of complaint. But we cannot retaliate against them in any way, whether that's in areas of pay or training or promotion or transfer, or however that may look in your organization. In other words, we've got a lot kind of stacked against us in the fact that there are so many laws, and harassment, as you can see on the next slide, is defined again in so many different ways, and it's very inclusive around physical, verbal conduct, so even showing hostility towards an individual because of their protected class. The EEOC, the investigation agency of charges that are filed by employees, defines sexual harassment again as unwelcome physical or verbal in nature. So it's a very broad brush that they paint this with, and they leave a lot of discretion to themselves as the agency that conducts these investigations. So it's a very broad situation that we need to be concerned with. I do want to spend and close with what the most common form of workplace harassment is that sexual harassment. We've all heard of horror stories around this. Again, in the workplace, it's around unwelcome sexual advances, any request for sexual favors, that verbal or physical conduct that enters into some type of decision, any type of employment decision, or even unreasonable, what unreasonable infers is with an organization's work performance. In other words, it creates an environment where someone cannot perform at their best. If we are responsible for providing that safe work environment, then we have to eliminate any hostility or offensive type of activities, words, or intimidation from that. We can be held liable for that. Let's look at the different forms of sexual harassment so that you'll have an understanding. One is the quid pro quo. We'll look at that in more detail in just a minute. I just talked about hostile work environment. There's been court cases now of same-sex harassment, even non-employee harassment, and third-party harassment. I want to break these down just a little bit because this is some things just to be aware of in your workplace. For decades and decades, most of your sexual harassment claims were filed under the quid pro quo. And what that means in Latin is basically something for something. In other words, if you perform this sexual favor for me, then I'll ensure that I'll take care of you on the other side, whether that's with a promotion or raise, continued employment, whatever that may be. So that's based on a sexual activity, a sexual favor, and that conduct is seen then as justification for receiving some type of tangible benefit. You do something for me, and I'll do something for you. That's the definition of quid pro quo. What we see more often today is that hostile work environment, where the harassment is not just a single incident or a single word or a single physical contact, but rather an environment that's created that's offensive. And that's, again, is painted with a very, very broad brush of what that may look like. And basically, it's just an environment that will not allow an employee to perform their role, their task, their job at the highest performance. In other words, if they're distracted by some conduct, by some words, by some jokes, by some written communication, then they have a charge against the employer for not providing that safe work environment.
One of my best stories, and this is real, my wife has a good friend, and I call her my Seventh-day Baptist because she's a very serious girl. She studies her Bible on lunch breaks, and she's very nice, and she's very attractive. She went to work for a significant corporation here, and she got put out in the marketing department with about 4 or 5 typical salesmen with a little bit of what my mother used to call packing house language. And she sat there in her cubicle next to these boys using these, the Lord's name in vain and everything else. And in about an hour, she went down the hall to the president, shut the door, and said, "You fix this, or you're going to have a big problem." And he was smart enough to bring those boys in and say, "No more of that kind of language here while we're working together in the office." And and these kids today, they'll pull the trigger. They're, this is not the old days when I grew up where women would just kind of put up with it and go home and let it go. These young kids today, they'll just pull the trigger on it.
Yeah, and that's a good example of having that safe work environment. Anything that's offensive, anything that is offensive that affects someone's performance, what I call a distraction, can be used as a charge against the organization. So that's a good example. Let's look at some other forms. Well, here's a little bit more on that hostile work environment. We're just not talking about the people on your immediate team. These can be others. These can even be vendors in a situation. It could be customers. The slide refers to a doctor's office, even patients. So it's much broader than that. Again, anything that enters into that work environment, we're responsible for managing. It's not just limited, again, to sexual advances, but it can include, offensive remarks or offensive behavior about the person's sex or sexual conduct. It can even occur, indirectly, as long as it interferes with their ability to perform their job. That's the key requirement. If they can say that I've been distracted, that I'm not able to be successful on role, that I'm not able to be as productive because of these offensive circumstances that are out there, then that is what we need to be dealing with and making sure that there's not a hostile work environment that is being created by those that are around that individual. Let's talk about some other forms of harassment briefly, but same-sex harassment, whether that's male on male or female on female, the Supreme Court's held that also is illegal and something that's, again, not tolerated, and we should not tolerate that in our workplace. Non-employee harassment. This deals with individuals that come in contact with customers, with vendors, with visitors. Anything that is within the scope and course of their employment or within our workplace, we have a responsibility and need to have an understanding that these can lead to sexual harassment charges and sexual harassment claims. One of the ugliest sexual harassment claims I ever dealt with was actually from a customer. It was actually from a customer, from a sales individual, and the sales person that was the employee was a female, and the female was actually requesting sexual favors from a male customer in response to getting discounted rates from the organization, discounted products and discounted services. And the reason those non-employee harassment claims are so difficult to manage is that you don't have direct control, even access at times, to those people that are involved in it. So your hands are a bit tied behind your back, and you're put into the fight, and you don't have any resources to draw on because those individuals are not even accessible to you to talk about the circumstances or to get written comments. So something to be aware of. I had another claim where a copier service technician was coming into the facility to perform services on the copier and harassing one of the female employees there. When circumstances like that arise, we need to take action. The proper action in a circumstance like that is to pick up the phone, call the rep at the copy, whoever you have that contract with, that copier company, that service company, and demand that that individual not come back on your premises. That's not the only technicians they have in town. They can send somebody else by.
Probably the best place to start there would be the salesperson who has that account, because they certainly don't want it.
Yeah, exactly. And the point is to act on it.
Yep.
The point is to be aware of it, to recognize it, and then once we do, then we have that obligation to act on it. And if we don't act on it, that's when we get into trouble, and that's when individuals don't understand why things aren't being handled, and they go elsewhere to find their answers. And a lot of times, that is in an attorney's office, as we all know. So let's talk about the individual that's being harassed. What should a victim of harassment do?
Well, I think the most important thing, which is never very clear, there needs to be a confidential pipeline to somebody with the power to fix the problem. And that may be a kind of a convoluted answer, but most people are afraid to get too much stirred up, because they don't know who's on whose side or what's going to happen. So there has to be a confidence in the fact that if I go see the president of the company with the door shut and say, I got a problem with the vendor, I got a problem with Joe in accounting, whatever it is, if she feels it's significant to be upsetting, she's got to know that she's going to be okay. And I think in a lot of companies, people are afraid that they don't have a real solid conduit to be protected when this thing starts to go to pieces.
Yeah, definitely the right answer on that, Larry. And some organizations have several channels that you can communicate that with. You may need to go to your manager. You may need to go to some HR professional. You may need to go to someone in the ownership of the organization. Whatever those channels are and whatever works for you is most appropriate. But again, establish those. Think about those and what makes sense for your organization. One of the training tools, if you have the opportunity to talk to a victim of harassment, is for that individual to ask that person to stop. In my 25 years experience in corporate America and dealing with harassment claims, 98% of the people wanted the same thing. They weren't looking for a lawsuit. They weren't looking to file a charge with the Department of Labor. 98% of the people just wanted it to stop.
Go to work, do your job, not be bothered.
Exactly. So one of the most effective ways is for that individual, when they're approached, is to tell them to stop it. It's inappropriate, I don't appreciate this, and I'm asking you to stop it. Now, you need to follow that up to Larry's suggestion by reporting it as well.
You need to document.
Reporting it through whatever communication channels are available and whatever makes sense in your organization. But encourage that individual that if ever happens again, that they have an obligation or responsibility as well to themselves and to the organization to ask for it to stop. Whatever words they want to use, whether it's inappropriate, they don't appreciate it, but tell them to say the word stop. So that's one of the most effective ways that we have. There's some other ways that employees, let's talk about vicarious liability and what this means. We've talked about the liability that's out there, the risk that's out there to the employers, but vicarious liability is what the courts have held, that managers and employees' actions can liable organizations. In other words, the actions and the behaviors of employees and managers can put that organization at risk, and they can be held, the company can be held responsible for that. So what are our responsibilities? We need to monitor the workplace. We need to ensure that it's safe, that people are being treated with respect. Treat all the complaints seriously, take appropriate action. We need to have some type of policy out there so that individuals understand what the law says and what is accepted in the organization. We need to respond to allegations immediately. Report those complaints to HR, to whatever the proper authority is, and we need to take corrective action, whatever that means. But we need to take corrective action as the manager and as being that responsible party. And emphasize again, ensure that there's no retaliation. No retaliation. And as Larry said a minute ago, then we need to document everything that's happened and what we did to correct it and why we did that. The documentation is most important, because if you do have a complaint, you do have a charge, you do have a lawsuit, the first thing that you're going to be asked for by an HR professional or by legal counsel is to please send us your documentation. That's the first thing they're going to ask for, is please send us your documentation. Because their view is, if it's not written down, then it didn't happen.
That's right. Another issue that's subtle but ties into this whole thing when it comes to management responsibilities. Anytime you see one of your, and I'll just say gals, because it's typically one of those problems that is getting harassed by her ex-husband or boyfriend, whatever's going on, and she's out there in the front lines, front desk receptionist or whatever, as we've seen on TV and hear all the time, those employees are vulnerable to some kind of really terrible accident or incident. And as an employer, you have a responsibility, if you're aware that this is getting to be a problem, to either make sure that you walk this person out to the car every night to make sure she gets in her car and gets off the property, or that you move her into the back area of the building where nobody can get rapid access to her. We just had a horrible thing down there with the guy cutting people up. Frontline girls right there in the front, and boom, guy walks in and starts cutting them up. You can't defend everything, but be aware that if you, particularly with gals, it's a serious problem in the workplace with women who get exposed to these kind of issues. And if they're on your property, you have a responsibility to try to protect them.
The manager has responsibilities, but I'm also going to say that others in the organizations, including employees, know what their responsibilities are. They need to stay away from this bad behavior. They need to stay away from any type of jokes or comments or what they put into emails. They need to understand that. It needs to be part of your policy. That needs to be part of your practice in your organization. There's a lot of different things that we would not appreciate or accept in our workplace, as far as touching, as far as personal space. So employees need to be aware also of their responsibilities in creating a safe environment for all of us. So it kind of goes both ways. There's management responsibility as well as employee responsibility, but the employee responsibilities need to be communicated, whether that's in some type of orientation or some type of handbook or some type of session, training session. It needs to be communicated clearly so they understand what their role is. We don't have time to go into all sorts of the other types of harassment or discrimination. We've touched on those briefly. We've talked about some dealing with age. But there's, unfortunately, a lengthy list that we need to be concerned with. And if you have questions or concerns about something that's happening in your workplace or something that you've seen before, that you want to work on preventive measures, don't hesitate to contact us here at Partners. In closing, I want to give an opportunity for folks to ask any questions that they may have. You can take your phones off mute and speak on the line, or you're welcome to type any questions in the chat box. We'll give you just a minute to respond to that. As we're almost out of time, I do want to note that on the screen is my contact information. Again, you're welcome to send me a note, call me here at Partners for a copy of this presentation, or any questions around anything we've talked about, concerns that you may have, whether it's around policies or charges or practices that you've run across in your organization, particularly on the preventive side.
And we do have an employer's practices liability insurance program that we can share with you. Is that correct?
Yes, sir.
I mean, we do have a coverage that we can incorporate into your payroll, which gives you that little dollar per head coverage that insures you against some of these losses. It only takes one for most people to say, man, was that a bad experience.
That's for sure. A quick reminder of our upcoming webinars that we have. Again, we're doing these monthly. So you can see next month we've got some HR tips and traps for supervisors that we'll be discussing. So we'll get those dates and details out soon. You can share by the end of the week. This particular webinar will be posted at Partners HR. If you have other folks in your organization that you think would be valuable for them to take some time and review this webcast, then please direct them to Partners HR. I think that concludes our webinar for today, and look forward to you joining us next month. Thank you.
Thank you.